Hello, today we're going to talk about the difference between criminal mandatory protection orders, CRS 18-1001, and civil temporary and permanent protection orders. Each case is very different. This little video is going to be the high points of everything, but if you want an individual assessment of either one of those criminal protection orders or civil protection orders and what your rights are and your options are, please give us a call for a free consultation at 719-447-1923. The biggest difference between a criminal protection order and a civil protection order is which courtrooms they would be in. The criminal protection order stems from a criminal charge against somebody. So if you're a victim in the case, whether it's domestic violence or someone stole money from your establishment, in 18-1001, a mandatory criminal protection order will be put in place, restraining the defendant from contacting you, from coming within 100 yards of either your business, your home, or any place you'd likely to be, and it prohibits them to try to communicate to you through third parties. The biggest difference is you can't start a mandatory criminal protection order. The DA's office has to, or law enforcement by initiating a criminal charge. To make modifications to a mandatory criminal protection order, you have to work with the deputy district attorney assigned to your case to file motions into the court, whether it's a felony or a misdemeanor case, and the judge would make the ultimate decision, the criminal judge. So if you were in a relationship, you're married, you're going through a divorce, your spouse is charged with a crime, domestic violence charges are assessed, but you still want to be able to talk about the divorce, you still want to talk about the well-being of kiddos, exchanging of property, you can file a modification of the criminal protection order through the DA's office to set up strict scopes of communication. If the restrained party exceeds those scopes of communication, that is another crime. That is a violation of a criminal protection order. If you have been in an intimate relationship and they violate those terms, that's another domestic violence charge, and it can really snowball for the defendant in that case. The duration of a mandatory criminal protection order is the life of the case. So if an individual goes to trial and defendant goes to trial and is found guilty, you'll have at least 2 years of a criminal protection order in place if it's domestic violence due to the requirements under that statute under Title 18. It's going to be a 2-year protection order. If they take a plea agreement, the defendant, it will be a mandatory minimum of 2 years of the criminal protection orders in place. However, if they are acquitted at trial or the district attorney's office decides to dismiss the case, that's it. The criminal protection order is done. You're not going to have any protection through that case any longer. The civil protection order can either substitute or concurrently help out that criminal protection order. A civil protection order is brought by the individual. So if a husband or wife needs protection from the other side, or just needs some time through a temporary protection order to restrain the other party from coming near them so that they can set up their exit from the home, they can set up their exit from the relationship if there's any power and coercion being put on them, you go to the El Paso County Courthouse, Pueblo County Courthouse, Teller County Courthouse, Douglas County Courthouse, your local courthouse. You fill out and write out the complaints. You have to allege in the temporary protection order complaint with dates and times and specificity what happened. And what happened has to relate to, was there physical and or emotional harm perpetrated by the respondent, the potentially restrained person against you, and how do you know, or what actions have they taken to show you that that behavior is not going to stop unless there's a protection order in place, a civil protection order. So you write that out, you submit it to the court, it goes to a magistrate. The magistrate will review it. They have a rubric, they have a statute in which they have to base the issuance of a temporary civil protection order off of. And again, that is there any physical and or emotional harm? And will that physical or emotional harm continue unless the court steps in and creates an order restraining them from you? You can still modify a temporary protection order or a permanent protection order, just like the criminal protection order, where you can allow for finite scopes of communication. You can allow for being in the presence of one another during parenting exchanges or exchanging of property. You have a lot more control over that. After you bring the protection order in, after the initial magistrate approves the temporary civil protection order, They will give you the citation. They will give you the actual document that is the protection order complaint. It will have a court date on it. They'll also give you some more disclosures. It's imperative that you have all of those documents, because then, unlike the criminal protection order, which will be issued by law enforcement, the jail, or the courthouse, you have to effectuate service on the restrained party. You have to go to either a private process server and pay them to take those documents. Again, critical. Make sure you have exactly what the court told you to serve. But a private process server would take those documents, find them, and literally hand it to them and say, you've been served with the civil protection order. You can also use the El Paso County Sheriff's Office. They have a full department that handles personal service. Sometimes, I don't know if they're doing this currently, but you can ask to have any fees associated with service waived. You can also use an independent person that's 18 years or older that has nothing to do with the case to do it yourself. The cleanest way is either the sheriff's office or the private process server. Until that document, that protection order is served on them, it's not in effect. So if they violated any terms and you call the police are going to look up the database and go, I don't see an active civil protection order, there's nothing I can do. That doesn't mean if the restrained party is actually committing some sort of independent crime, the police aren't going to do anything. They absolutely will. But if it's coming within 100 yards of you, and they're not threatening you, and they're not being insane, and you have not served that civil protection order, the police will do nothing. After that, you go to Division N in El Paso County, and you will tell the court that you want a permanent protection order. You can also continue a temporary protection order up to 1 year from the date it was filed without a hearing if the restrained party agrees, or you can ask for a continuance at any duration less than a year. You are also guaranteed a 2-week continuance if the other party objects. So again, the big difference is the mandatory criminal protection order is effectuated by law enforcement, the courts, and the DA's office. The civil protection order is affected by you, and there's different burdens. So the civil case, the civil protection order has a preponderance of the evidence burden, which is much less than potentially beyond a reasonable doubt in a criminal case. So a lot of times, if you feel that the criminal case isn't necessarily going the way you want it to go, and you still have colorable, independent evidence that the restrained party is a threat to you, you always have the civil protection order process. Our law firm, we prosecute these. We work with TESA through Project Lift. We probably do, between all of us at the firm, 5 to 8 protection orders a month. We also defend these, so we know both sides. Everybody at this law firm is also a former deputy district attorney out of El Paso and Teller County. So we know the rules of evidence, we know the negotiations, we know the statutes, and we've been very successful defending and prosecuting these. So if you have any questions stemming from this little video here, please give us a call. You will likely talk to me personally, and we can have a free consultation. So give us a call, 719-447-1923. Thanks.